Hello, and welcome to Defense Diary. I am your host, Bob Mata, and this is our continuing coverage of the Commonwealth of Massachusetts versus Karen Reed. So what's up, y'all? I am in beautiful Tennessee, like central Tennessee. Just got out here yesterday. Allie crushed it last night. I was trying to peep some of that live last night. She did a great job. And today, this hearing, it could be short. We got an order down from Bev, Green's in. So we're not going to be having a full Daubert. The reason I kind of wanted to stream this morning is we might get to hear a little bit about this motion to dismiss that Jackson was promising was going to be filed. So fear it's worth checking out. It could be brief, and if it is, this live will be brief. So they'll go hand in hand. And I've got probably 9 guys because we're expecting probably about 6 more. So there could be horrific interruptions during this live. Who knows? Who knows? It's early. I was hoping all these guys would be sleeping still because they're all hungover, but I'm the only one that doesn't drink. So, best laid plans. I heard them up and walking around. Yeah, no, I'm good, Susan. So I traveled earlier in the week for a family emergency. Yeah, that's not great news. This is my annual Super Bowl trip with my buddies where we typically just come to my buddy's house in Tennessee, but it's fun. We've been doing it for 20 years. So, oh, thanks, Kaylee. Appreciate that. So this thing's supposed to go at 9 a.m. I'll keep an eye on it. I haven't found like a stream on Boston 10 or 25 yet. I'm gonna keep looking though. I've got yeah. I just see one scheduled. I don't know. I think Mandy's looking forward to. So, like the sound has not been good. Mandy, did you have any luck finding the stream? I'm only finding LNC for it, which is fine. I can use that. All right, hold on. There's so I don't have my normal setup. So I don't have my second screen. So I've got one screen, which is it's more difficult because you're sharing a screen and I won't be able to look at the comments if I'm trying to monitor the screen to be able to pause and things like that. So, and I think Allie has court today, so she's not going to be hanging. I don't think. I think that's not happening. So, okay. So yeah, we'll keep an eye on this. So what was good? What was good with Delphi? How was that live? I couldn't hear it. because I could watch it. I was at a basketball game, a Tennessee basketball game, which they pulled out, which is good. Last year we went to the game and it was looked like Tennessee had it in hand, and then all of a sudden they just kind of collapse at the end and lose in stunning fashion. And thought it was great. I was just it's like where you're at a game and you don't have any kind of stake in it, like you don't care who wins. Even though all my friends wanted Tennessee to win, I didn't really care, So it was like, and just to watch all the air get sucked out of the stadium. I've been on the I've been on the tail end of that so many times with all the Chicago sports teams that it was nice to have it happen to somebody else instead of me. Just to like have that, and it's only a game, you know what I mean? So it's yeah, it was I couldn't help but laugh. It was funny. It was like, I think the dude hit like a half court three to win the game. It was crazy. It was funny. It was funny. All right, so let's see. Keeping an eye on it. Let's see if I've got the ability to be able to share here. Broken Baker over in Law and Crime Chat, hanging out. All right. So we'll keep this up. We'll see when that thing goes live. Welcome. Welcome to the family, Kaylee. Aw. Family hug. This is true. This is true. I don't worry about things I can't control. There's no point. Can't do anything about it. Yeah, let me know, Mandy, if you do find a different local. I thought the sound on the local was moderately better. Hey, what's up, Kelly? Good morning. Good morning, all you beautiful humans. It's good to see you. It's good to see you. Is it pretty quiet in here? I try to use door jams to keep them out, all my friends, because they'll be very disruptive, I predict. That's what I predict. Very, very disruptive. We got a small crew, 99. Oh, oh, oh. My plan has worked thus far. Somebody was just foiled from getting in. Oh, yeah. Can I help you? Yeah. I don't know which one it is. I don't know who. Oh, man. Wow. Oh, I forgot. Yeah, one of my friends is his clothes are in here, so he's gonna have to get in here. He's crawling on the floor. What a guy! Oh, can you see his head there? There he is.
Hello, Defense Diary people.
It's my buddy Hector.
Hola. Adios.
Oh, buenos dias. Buenos dias. That was a good job getting that door jam out, though. It's pretty. Thanks, Mike. Appreciate you. Appreciate you, man. Appreciate you. So, Tracy, did you send the order? You sent the order. I thought I saw that. Did you email it to me? You know how I am about getting it via text. Doesn't work for me. I need it. I was trying to see if I could pull up Judge Bev's order so we could see. So the way that they had basically set this up for today, it was like they had carved out, and we're talking about Reed here, obviously, but they had carved out Thursday and Friday in the event that Judge Bev was going to rule that there was going to be a full Daubert hearing. That is not taking place, from what I understand. And that means that there's probably some housekeeping. Jackson was talking about his motion to dismiss, which I think she wanted him to have filed by Monday. So, like this upcoming Monday. But I'm hoping that we can, I thought she said something about him briefing it a little bit, kind of giving an idea of what she can expect, kind of what the thrust of the motion is, so that she has an idea. Maybe I was hearing things because she was pushing him to have it done by today. And he was like, there's no way. There's no way we're going to be able to get it done this early. So we'll find out what's going on with that. We still have the pending, we could have the ARCA hearings today with Rensselaer and Wolf. Those could definitely be going down today. And that was, again, Brennan and the Commonwealth is trying to say that because the feds are not going to be able to comply with Rule 14, which is it's the reciprocal discovery statute or rule. There's certain things that they're not going to be able to comply with, that therefore either the testimony and or portions of the testimony should be barred. So that could be up today. That's still out there pending. As far as pending stuff, I think that one is the only one that I know of. Oh, wait, let's see. Let me check this out. Oh, okay, good. Oh, perfect. Thank you, Tracy. Okay, so we got this one. Okay. All right, so we got that. Okay. All right, so I got one of them. Okay. All right. So I'm going to pull this one up first. Trace, was there only the one order? Because one looks like it is a. Okay. Hold on. I'm going to stop the screen. I'm going to pull this order up. So this is relating to Voss, who is the reporter. So let me. Where's that guy? Let's see here. Okay. I should be seeing this. Maybe not. My one, oh. Huh. Yeah, it's weird. I'm not seeing my my Acrobat tab. Mandy, are you back here with me? Strange that I'm not able to see that. All right, so I can't figure it out. I don't know where it is. It's bizarre. I don't know. All right, so you guys aren't going to be able to see it, but I'm going to read it. Okay, so we've got. Let me get these two things. All right, so on. It looks like it was the 31st, so shortly after, the judge entered an order saying it was her memorandum of decision in order of non-party Gretchen Voss's motion for reconsideration of December 5, 2024 court order regarding the record's disclosure. So non-party Gretchen Voss seeks reconsideration of this court's December 5, 2024 order compelling production of confidential handwritten notes of an off-the-record interview she conducted with Karen Reed. In support of her motion for reconsideration, in addition to her memorandum, Voss filed a second affidavit and the Massachusetts Newspaper Publishers Association, New England First Amendment Coalition, New England Newspaper and Press Association, and Reporters Committee for Freedom of the Press filed an amicus memorandum. Given the additional information presented in the aforementioned filings, excuse me, and after an in-camera review of the handwritten notes at issue, the court has reconsidered its December 5th, 2024 order. The court concludes that the content of the quote off-the-record notes at issue are of a different character than the unredacted recordings of the on-the-record interviews produced pursuant to the court's previous orders. So Voss has articulated a compelling argument that requiring disclosure of the notes poses a greater risk to the free flow of information than the other materials produced. Conversely, the Commonwealth has not demonstrated to the court that its need for the handwritten notes, separate from the audio recordings, outweighs the danger posed to the public interest in the free flow of information. Accordingly, the court allows Voss's motion for reconsideration and will not require disclosure of her handwritten notes of July 7th, 2023, the off-the-record interview. So there you go. There's that. Now, I'm not seeing anything about green. Did I make that up? Was that true? Tell me in the chat. Has she said green's in? Do you guys know? I could have sworn that I heard that. Could have sworn that I heard that. So I don't know. Pull this guy back up. Keep an eye on that. All right. And then there was another thing that was filed. It is a very well-lit room, and it's very well lit. It's got a lot of windows, so it's good. I'm at my buddy's place, overlooking a nice lake. It's very picturesque. It's nice. Oh, read her messages. Thanks, Oasis. Okay, let's see. Takes a team. All right. Back in court. Okay. All right. Okay, let's see. Let's see if I can find this one. Okay. All right, bear with me, y'all. Okay. I like Boston 25 because they have the thing running like while it's let's see. Okay, so it's still huh. Okay. So let's see. I'm gonna go to this. All right. So she found it in the local tab. Let's see. Hmm. All right. Yeah, we might have a full hearing today. I don't know. Okay, let me see. I'm still looking for y'all. 25 news, local. Yeah, it's weird. I'm seeing what Mandy sent me via text, but I'm not when I go to the same website. Oh, wait. Maybe it's here. Boss 25. No. Don't they have a YouTube channel? Like what? Am I in Crazy World? They have to have a YouTube channel. Let's see. Okay. All right, let me try to. See if it's on here. Oh, here we go. Here we go. Did it. Did it. Got some hot mics going and everything. Exciting.
Oh, I know it.
Super hot mics.
Yeah, hold on.
Mandy, can you switch the? Can you cover that? Oh, perfect timing, y'all. Perfect timing.
All persons have any business before the Honorable Beverly Canoni, Justice of the Norfolk Superior Court, and for the County of Norfolk. Draw near, give your attendance, you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated. My name will make sure your cell phones are off and put away.
22117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves, starting with the Commonwealth?
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
Adam Lally for the Commonwealth.
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson from Ms. Reed.
Good morning, Mr. Jackson.
Morning, Your Honor. David Dinetti for Karen Reed.
Good morning, Mr. Yannetti. Good morning, Ms. Reed. All right, so to start, I'm going to start with the Commonwealth's motion to exclude defense witness Richard Green's debunked opinions. So after review of the pleadings, it's clear to me that the issues that give rise to the dispute do not invoke the gatekeeper function of the court. To me, it's rather a difference of opinions that need to be resolved by the jury. So I'm denying your motion. I'm not going to exclude the evidence. All right, so then I think what I'd like to move to is the defendant's motion to recover expert-related expenses from the Commonwealth. I did get a response from the Commonwealth on this, so I need to hear, Mr. Jackson, what it is you're asking me to do.
I mean, she follows the law most of the time. Like I know people say she's biased. All judges or most judges are biased against defense attorneys. Just get used to that concept. That's a concept that is just like omnipresent in every courtroom. Like most judges are pro-state. She follows the law. Like I like when you watch and read about Judge Gull over at the Richard Allen trial in that case, that is what bias looks like. This is not like she's allowed everything that the defense has tried to get in first trial, and thus far she's made the right rulings here too. So I don't know. I actually like Judge Bev, so and I don't care what anybody has to say about it, frankly. Where I'm at, it's where I'm at with it.
And why?
The court did receive the addendum filing the court asked for as well, correct?
No, because I've been waiting for it and I do not have it. And I checked as recently as 5 o'clock yesterday and this morning.
I'll get it.
Okay. Do you have an extra copy for me? Because I don't.
It was coming from, the final copy was coming from Miss Little from back in my office. That was.
When did she send it?
When? Yesterday, I think I was on the plane.
Margaret checked for me yesterday.
I think it was yesterday afternoon, I really do. I remember.
Can you come here for 1 second, please? Who is she? Did she send it to all the clerks like she's supposed to, or just Mr. McDermott?
I think she sent it to everybody. Her normal filing.
I'll check it. Yeah, no, Judge reminds me, I did get something else. It wasn't Chris.
It was from the Commonwealth, so I've been waiting for this, so I need a
That
minute
was
to
sent
read
at
it.
12:57 p.m. yesterday.
I did not get it.
No.
Are they talking about the motion?
More
to
importantly, the
dismiss?
Commonwealth got it, right?
Yes, that's my copy I handed to Council.
Oh, thank you.
Thank you, Mr.
No, it's due Monday. I don't know what they're talking about here, though. I missed it because I paused it. Okay, thank you, Kaylee. The addendum to the motion to recover. So they're talking about trying to recover expenses that the defense has outlaid that they feel was just a move by the prosecution trying to burn through Karen Reed's money, which that happens. That's not some conspiracy shit. That's a strategic move a lot of times. It can't be frivolous, though. I mean, that's where you get motions like this. If there was something frivolous that was filed and the defense had to dig around and find an expert and pay that expert and fly that expert in and pay the expert to testify, and it was all bullshit, then they'll come in and ask for some cash. What's up, Donna? Missed you too. So glad to see you. Yeah, so this is going to be a short day, y'all. Short day of hearings.
To save me time, does your expert in his affidavit say that this information was erased or that it wasn't there?
Wasn't there.
Okay.
It was erased by an operation of automation.
But do I bother reading your expert's affidavit again so it's not in there?
And I'll address what
All right.
our concerns are in my oral statement.
All right. I hear
The
you.
court- May I?
Yes.
The court started by asking, what is it that the defense is asking for? Basically, we're asking to be treated equitably and fairly. This really is an issue of equity, an issue of fairness. And the court maintains this court maintains the inherent authority to issue sanctions when there is an injustice. And those sanctions can include something like cost shifting sanctions. And there's a body of law that exists that deals with this exact thing. And that body of law includes the case of the Committee for Public Counsel Services versus the Attorney General. That's at 480 Mass 700. It's a 2018 case. The court may remember what was, I think, pretty widely known here in these parts, which was the Amherst scandal. Had a bunch of cases going back from 2010 all the way through.
I'm very familiar with the case.
All the way through 2018, and it culminated with Justice Gaziano discussing in his opinion, single justice opinion, exactly these types of things. And what Justice Gaziano said was, quote, the Attorney General does not dispute that the court has the authority pursuant to Rule 14, sub C, sub 1, to impose remedial monetary sanctions for a discovery violation. And he cites Commonwealth v. Firth, indicating that sanctions may be imposed under Rule 14 for failure to comply with discovery obligations, and sanctions should be tailored appropriately to cure any injustice resulting from a party's non-compliance with its discovery obligations. So the real question before the court today is and really the only question before the court today is, has Ms. Reed suffered any prejudice based on blatant discovery and Brady violations by the Commonwealth? And the answer to that question is a resounding yes, she has. Your Honor, Ms. Reed, as the court knows, is on trial for her life, and she's been expending precious resources for some 3 years now, defending herself against provably false allegations. And at the center of that storm of defense are these Sallyport videos. It should be pretty straightforward, really. I mean, it's just a series of videos at a particular location for a particular time. And that time is January 29th, 2022, from midnight until 11:59. It's a 24-hour period, 23 hours and 59 minutes. Should be pretty simple, but it has been anything but simple in this case. We've been asking for a full download of every single one of those cameras and all that footage from January 29th, 2022, from 12 a.m. to 11:59, but we've never gotten it.
When did you first seek it?
We asked for the preservation on February 2nd, 2022, when Mr. Yannetti said retain and maintain all physical evidence. We've been seeking these videos since well before the first trial. We didn't get them before the first trial.
Do you have a date? Do you have any chronology for me?
I don't. I can certainly provide those, but it's been.
I'd like that. I mean, that would be.
I'll be happy to do that. It's in discovery request after discovery request after discovery request. Basically, there's also a catch-all. We've been asking for all physical evidence concerning video footage from Canton PD from well before the trial. We didn't specify which cameras because we didn't know which cameras had video footage. We didn't know how many cameras there were, but we didn't get anything from the Commonwealth. And I'll address that in particular in just a second. Mr. Lally didn't give it to us before a full download, before the trial. The Commonwealth didn't provide it during trial. And today, as I stand here, we still don't have it. And interestingly, Mr. Brennan does make mention in his opposition that, quote, at no time has the defense ever made a formal preservation request. I found that interesting for two reasons. And I have two comments about that. First, as the court record reflects, on February 2nd, 2022, I just referred to it, Mr. Yannetti filed a preservation demand for, quote, all physical evidence to be maintained. That DVR, the footage on the DVR, is physical evidence that was required, not requested, but required to be maintained by the Commonwealth pursuant to that demand. But second, and this is probably more important, it wouldn't have mattered if we didn't ask for it to be maintained. It wouldn't have mattered if we didn't ask for it to be preserved. This was a self-executing duty by the Commonwealth. As Justice Gaziano stated in the same case, the Committee for Public Counsel, quote, a prosecutor's core duty is to administer justice fairly. To fulfill that duty, a prosecutor is required to turn over exculpatory evidence to a defendant without regard to its impact on the case. The failure to disclose evidence favorable to an accused that is material either to guilt or to punishment is a violation of due process. Litigation strategy plays no role in this process. Under our rules of professional conduct, a prosecutor is required to make timely disclosure to the defense of all evidence or information known to the prosecutor that tends to negate guilt of the accused or mitigate the offense. And he cites Massachusetts Rule of Professional Conduct 3.8, subsection D. The Commonwealth's Brady obligation is self-executing, Your Honor. It wouldn't have mattered one whit if we didn't ask for that footage, but it turns out that, in fact, Mr. Yannetti did ask that it be maintained. And the Commonwealth has still failed to preserve it. What we have gotten, it appears, are scraps and fragments of videos that the Commonwealth has decided on their own, and within their own time frame, to dole out to us over the course of months and years. And included in that scrap and fragment was a video that was missing 42 minutes. The court is well aware of this video. It was heavily litigated and heavily referenced at the first trial. That's the exact time frame. The missing portion is the exact time frame that the SUV was being pulled into the Sally Port. We got that video on April 4th, just days before the first trial. Keep in mind, it's a video from January 29th, 2022. Another one of those videos was the inverted video that has now seen some fame, that the Commonwealth tried to sell to the jury as a true and correct copy of a video within the Sally Port, and we got that one after the trial started, in the middle of trial. So why were we getting videos from January 29th, 2022, 2.5 years later? And why were some of those videos altered or manipulated and not in their proper format? We still don't have answers to those questions. And literally, while we're asking that question and while we're pondering that question, a couple of days ago, we're getting yet more videos, scraps, piecemeal. We got another Sally Port video just a few days ago, this one showing the Lexus backing into the Sally Port from some exterior camera. And that also is exculpatory evidence. Mr. Brennan writes in his opposition that the idea that the defense has been misled or was misled in its efforts to try to go secure that DVR footage is a distortion of the facts with, quote, no legal merit. Really? A distortion of the facts with no legal merit? Where's all this footage coming from, if not the DVR? It's the only place it was held. It's the only place it was captured. So of course we were misled by continually getting these piecemeal snippets of footage from the DVR, from the very source, had to have come from there, coupled with the Commonwealth saying, and Mr. Brennan saying, yeah, come on out, you can have your expert come out, meet us at Canton, we'll provide the DVR, you can have him look at it, he can bring his equipment, download whatever you want from that 24-hour period. So what were we to believe? That it was on the DVR. It had to be. How else were we getting these piecemeal videos? And they've had that DVR for 3 years. They knew exactly what was and what was not on that DVR. They had to have. This has been the center of a storm that surrounded this case from the jump. And to claim otherwise, it's just patently absurd. So Mr. Brennan also wrote in his opposition that Mr. Jackson said, don't touch the DVR, don't mess with it. So I informed Chief Rafferty, tell your staff, don't touch it, don't mess with it, almost suggesting, intimating that it's my fault that we didn't know what was on the DVR. That's absurd also. How am I supposed to know what is or isn't on the Commonwealth's DVR? What I actually said, that was a sort of a liberal interpretation of the facts. What I actually said was, Mr. Brennan, do me a favor, if we're going to come out there, just don't have anybody download it in advance. Let's do it all together when we're all in the same place. That's what I said, and he accommodated that. He said, sure, we'll agree to that. So based on this history of getting these small clips from January 29th, we knew there had to be more footage. So when Mr. Brennan came on board, we made the request to him as well as the requests that we had made to his predecessors. We want all the footage for that 24-hour period. And lo and behold, we started getting more clips, more snippets, more piecemeal bits and bytes from that DVR. And one of them was a clip of Brian Higgins standing out in front of Canton Police Department in the parking lot in the freezing cold at 1:35 in the morning on January 29th on his cell phone. To punctuate the importance of that video footage, recall that this issue was raised at trial. We talked extensively. When I say we, both the Commonwealth and the defense, me in particular, spoke with Mr. Higgins about this issue. It was raised at trial, and Brian Higgins never once, not once, on direct examination or on cross-examination, admitted to having made a phone call in the middle of the night on January 29th. And yet now, after the trial, we get a video of him doing exactly that. And that also proves that he lied in front of a federal jury, in front of a federal grand jury, when he testified that he didn't have or make any phone calls in the middle of the night. That is called exculpatory evidence. And that's Brady evidence. And it was withheld in its entirety during the first trial and for the last 3 years. And it's against that. The reason I bring that up, Your Honor, it's against that backdrop that we then say to Mr. Brennan, kindly give us the footage. I don't want this piecemeal thing to keep going on. Just give us the raw footage. We'll send an expert. So the plan was put in place, and experts were retained, and flights were booked, and hotels were reserved, and transportation was arranged, and all at Ms. Reed's expense. She's writing the check for all of this. And our expert flies out to Canton, walks into the room, and within 10 minutes, they open up the front plate of the DVR, and lo and behold, the Commonwealth says and agrees, oh goodness, there is no footage. It was overwritten within 30 days.
Oops.
What?
Oopsies.
How
What?
could that possibly be?
What? Am I in crazy
The
world?
expert calls me.
Should have used my line.
Mr. Jackson, what do you want to do? And I said, I don't know. I'm not a tech. That's your job. I don't know what to do. If it's overwritten within 30 days, I don't know. Maybe there's a log. Let's find out who has access, whose digital fingerprints were on that DVR, who downloaded the footage, when it was downloaded. What about these clips that we have? I'm very confused. So the expert goes back and says to the technician for the Commonwealth, Colleen Crawford, well, let's at least download the log. At least we can have access to that, and we can start unraveling what's going on here. Oh, sorry, that's been overwritten as well.
Oh, man.
No
Oh, boy.
footage, you get no log. This was a complete and utter waste of time. According to the Commonwealth, that system, as I said, overwrites every 30 days. So by February 28th, I counted them. By February 28th, 2022, every single frame of that footage should be gone. So how did we get the inverted video in April of 2024? How did we get the video clips of Brian Higgins in October of 2024? How is that possible? The only explanation, Your Honor, is that the Commonwealth downloaded the entire system within the first 30 days. Otherwise, it's gone, admittedly. And all of that has been withheld from us for 3 years. Then to add salt to that wound, the Commonwealth allows us to go on this wild goose chase, spend $12,000 some odd dollars of Ms. Reed's money, and fly an expert out to Canton for absolutely no reason. Zero. The 30-day override protocol is something that their technician absolutely would have and should have and did know before we ever set foot in Canton. She was well aware of exactly why we were going out there. We were going out there to download footage from 3 years earlier. She knew it, we knew it, Mr. Brennan knew it, everybody knew it. But within 10 minutes of walking in the door, it was revealed that there, in fact, was no footage. And that's a fact that the Commonwealth had to have been aware of for the last 3 years. Yet Karen Reed is the one having to foot the bill for what turned out to be just a snipe hunt. It's not fair, and the Commonwealth should reimburse her
Snipe
for
hunting.
this fool's errand that was not of our making, of her
Snipe
making.
hunting.
The Commonwealth has since told us, Mr. Brennan told us, that remarkably he went to Canton PD, and this is in his opposition paperwork and his declaration, and he spoke with some officer. And that officer told him that he, the officer, personally made a copy of the entire January 29th video footage and placed that copy in some sort of an iCloud account. Not on the DVR system, not in the official data bank in which it's supposed to be stored, but on some iCloud account. And we're finding out about this in 2025. It's outrageous. What it is this entire situation surrounding this DVR and the Commonwealth's maintenance of that DVR and the footage on it is a complete dumpster fire. And Ms. Reed has to pay for the fire extinguisher. And that's not fair. The High Court and the Committee for Public Counsel, the same case that I referenced a little bit earlier, and the court will know this because this was sort of the big takeaway from that case, is Justice Gaziano fashioned a cost-shifting remedy against the Commonwealth and for the defense. And that included the entire cost of investigating and locating and contacting nearly, I think it was 10,000 defendants. It was an enormous amount of money and an enormous undertaking. And the Commonwealth had to foot that entire bill. And the reason they had to foot the entire bill is because the Supreme Court decided that it was prosecutorial discovery violations and cost-shifting remedies were in order. We're asking absolutely no more than that from this court. Fairness dictates that Ms. Reed be reimbursed. And I'll submit, Your Honor.
All right, thank you very much. Mr. Brennan?
Snipe hunting. Snipe hunting, bits and bytes, dumpster fire. Karen is the extinguisher, all
It's
of it.
notable that the defense purposely conflates two very separate issues. If you had a chance to read their motion, they suggest that they should receive costs because they hired an expert, came to Canton, and didn't receive the information they wanted. Yet today in the argument, they try to give you a historical complaint about the production of videos in this case. That is a separate issue. That's a Rule 14 issue, but that is not the motion before the court. The reason I suggest they conflate the issues is because they know their merit for costs. I mean, their motion for costs has no merit whatsoever. And so what they're trying to do is incite facts, invoke this injustice they've created so that the court looks at the motion that they actually filed and gets it distorted. It is disappointing to stand before a court and file an affidavit as an attorney and have someone else have a cross affidavit. Frankly, in my career, when that has happened on rare occasions, I find that embarrassing. There is very skilled and able attorneys in this courtroom, and to work out discovery matters and agreements is something that attorneys always should do. And that is what I've tried to do in this case. I have tried to give the defense the best opportunity I can to get whatever information they want, whether it is required or not required. Yet, I'm standing here today and I have to now share with you my conversations with the defense. I have to share with the court my position, which is contrary to the defense, because they have lodged a motion asking for money that they are not entitled to. If I stand back and do nothing and remain the dignity of the court, then what happens is there are claims that just float out in nowhere, and a lie unchecked becomes the truth. So now I must stand before you and I must tell you what happened. When I entered this case in September and I began to look at discovery, I saw a video produced in August from the Canton Police Department, and we immediately turned it over to the defense. I began a study of the case and tried to articulate and account for all evidence and make sure the defense obtained everything that they were entitled to and more. The defense asked me to try to account for the video because they believed it had been an issue in this case. I looked through the docket. There was no motion to preserve videotape. I read the pleadings. Attorney Yannetti was meticulous in his motions to preserve. It was admirable. It was meticulous, the work he did. There was no motion to preserve, and that has some import. It doesn't relieve the government of their obligation to provide Rule 14 discovery or exculpatory evidence or Brady evidence. It doesn't relieve the Commonwealth of their obligations to be dutiful, but it is difference in kind. Because the defense, if they want something that is not obvious, they put the Commonwealth on notice. Having practiced for almost 3 decades, you file motions to preserve within 24 hours, 48 hours, or 30 days. And so when Mr. Jackson called me, Attorney Jackson called me, and he said he wanted to come out and bring an expert to look at the NVR or DVR of the Canton Police Department, I had never seen that in 30 years. It's not part of our obligations. He's not entitled to come into the Canton Police Department with his own experts and download his request. But in the spirit of transparency, in an effort to help the defense so there will be a fair trial and they can obtain all the discovery, understanding the history of this case, seeing that there was an August videotape post-trial, I wanted to do what I could to accommodate them. So without any hesitation, despite that there was no court order, no motion to preserve, I invited him to come to the Canton Police Department. I called the chief of police. I asked the chief of police, although this was unique and novel, unprecedented, could the defense come and access their material? Typically, the Commonwealth will download it and provide them a copy. She had no hesitation. So I called Attorney Jackson back and I said that we would allow it. Attorney Jackson expressed concern, understandably, being a defense attorney, that almost 3 years later, the video may not be on the NVR. I had the same concern. I want all of the evidence. I'm not looking for evidence that's good for the Commonwealth or helpful for my case. I want all of the evidence.
Sure.
And so after he expressed the concern, I made clear I had no idea what, if anything, was on the NVR. We could go and look at it, but Mr. Attorney Jackson didn't want that. He wanted his expert to be the person to open the NVR. And respecting his position, providing a professional courtesy, I agreed. Didn't mislead him. I didn't think there would be video. I had no idea. So Mr. Jackson, Attorney Jackson, pardon me, sent out his expert. And by the way, the expert that came was not the expert they designated. I got a call because we were in court on a hearing that they had sent a different expert they hadn't noticed. And my response was, it doesn't matter. Whoever they send, let them look at it. And so when they did, not surprisingly, the information had been overwritten. Now, while there was a 30-day override on that machine, I believe the defense expert knows that there was a backup hard drive which kept materials longer than that 30 days. I do know that there was materials on that DVR, NVR, back in July of 2024, and I know that from a report that was generated by the Commonwealth and given to the defense, so they should know that as well. That may be one reason why they wanted to come out. They came out on their own volition. I extended the courtesy as much as I could, made no promises. I was clear, I was very uncertain about what would be on there since I never looked at it. After I learned there was no information on the NVR, I took the initiative and went to the police department. I viewed the police department, the cameras, I spoke to personnel, and I spoke to the retired individual who then was responsible for providing video upon request. And when I spoke to him, he told me in conversation that he would routinely store a copy on a file he noted as a detective file or on his hard drive. That was news to me. I thought that was helpful, so I notified the defense about my conversation. I was not trying to lure them back to Canton or have them spend money. I was trying to, as I always do, be as transparent as I could and as helpful as I could. Now, what I simply should have done and could have done is I could have gone to that detective file and downloaded the video and given a copy to the defense. That's my obligation, no more. But I didn't. I extended the courtesy that if they wanted to come and look at that file before we opened it, so it could be beyond reproach, they were invited to do that. I wasn't encouraging or luring them. I was inviting them because they had already been part of the process. I thought it would be disingenuous not to let them participate. And what they told me is to wait. So now that information, whatever it is, I don't know because I haven't seen it. And I've asked the detective or the retired detective not to access it. It is sitting in that file, supposedly. So at this point, it's the Commonwealth's position that we are going to go and download that information to give a copy to the defense. The defense waited almost 3 years. The defense was very clear about my uncertainty would be on that tape. And now they stand before the court and they try to parlay this into some type of injustice for their cause. The case they cite, Commonwealth versus Frith, the district court was overruled in assessing costs because there was no egregious violation. This is not a Brady case. This is not a setup. This is the government providing information as the case progresses and evolves and changes and retools. So what we have now is information, supposedly, on a database that we are going to get and give to the defense. You should deny their motion. Nobody was misled in this case. They've taken a professional courtesy and an effort to help, and they've distorted it into some type of injustice. Commonwealth's not going to be distracted from the cause in this case, which is a trial on April 1st. The court should not be distracted from the cause in this case. If they have a separate motion about Rule 14 violations, a motion dismissed for misconduct, that's a separate motion. That's not the motion before the court today. The motion before the court today is to attempt to recover costs for something they chose to do and that I accommodated. It should be rejected. Thank you.
Everything that guy just says,
Any quick
bullshit.
response, Mr.
Very,
Jackson?
very briefly, with the court's permission.
Sure.
By the way, it is a Brady case. There's no question that the data on those videos are Brady. They're exculpatory. That's where we start. So Mr. Brennan can say all day long, that's not a Brady case. Don't worry about it. Let's just sweep this under the carpet like we've done everything else. It's there's nothing to see here. That's not true. It's a Brady case because the information that we have now received from that DVR, that NVR system, is exculpatory to Ms. Reed. That's why I cited
Brian Higgins' part?
That's why I cited the Brian Higgins part. Correct. And I suspect there's a lot more on there as well. The inverted video part is also Brady, which we got in the middle of trial. Mr. Brennan says, basically, his argument is, deny the motion because they took a courtesy. I'm trying to be courteous. And he's a gentleman. This is not personal to Mr. Brennan. He seems to, the tone of his responses was, well, this is personal between Mr. Jackson and Mr. Brennan. It's not personal at all. This is about the defense and the Commonwealth. It's about Ms. Reed and the Commonwealth. But let's not conflate a courtesy with an obligation. The Commonwealth has an obligation. I don't care that Mr. Brennan wasn't on the case previously for the last 2.5, 3 years. It doesn't matter to me. This is not personal to him. I appreciate the fact that when he came onto the case, he immediately found in August, he found a video that had never been turned over. I can't fault him for that. He turned it over when he found it, apparently. What I can fault is the Commonwealth. Mr. Brennan was brought onto this case not to represent Mr. Brennan, but to represent the Commonwealth. And all the foibles, all the warts and blemishes that preceded him, unfortunately, are now his responsibility as lead counsel for the Commonwealth. He indicates that when he found out that we wanted to come look at the DVR, and we had absolutely no right to look at that DVR, this was just a courtesy, et cetera. Well, that might be true if we hadn't made the request, because we had been getting piecemeal videos from a DVR system that it supposedly was overwritten.
So the oral request by phone call you're talking about?
The latest one, right. So my request to come out and have an expert come out and see it. That's not just a courtesy. That's just good lawyering on his part and mine. You want to keep your hands clean, let's do it the transparent way. Have everybody come, bring their experts, whoever they might be, and let's download this stuff together. So there's no funny business, and everybody can wipe their hands and say, I didn't have anything to do with it except downloading the material, and whatever that material is, it is. That's just good lawyering. It's not a courtesy. He was doing that to protect his own and the Commonwealth's interests, and it was quite smart until he realized, because he didn't have any way of knowing it any more than I did, that there was no footage. It had been overwritten. Perhaps, certainly the defense was deceived. Perhaps Mr. Brennan was deceived as well. He indicates that he contacted Chief Rafferty, and she said, with no hesitation, yeah, bring him on out here. That lack of hesitation had anything to do with the fact that the chief knew that there was no data on the DVR. You come look all you want to. The bucket's empty.
Interesting.
I have no idea about this iCloud account or who owns the iCloud account, why this data on January 29th was moved from the DVR to the iCloud account. Mr. Brennan did say, do you want to have your expert come back out and watch as we download the iCloud account? And I said, let's defer that because this is literally, these are the contours of motion that's going to be before the court. And I still want to defer it because what I didn't want to do is pay another $12,000 or $15,000 for a second bite at this apple just to find out that iCloud account is somehow compromised as well.
Can you have someone record it? Can you have somebody that it won't cost you $12,000 if you want to come out and just have someone record it as it's being done?
Sure, I didn't mean to interrupt the court. Yes, I can certainly make accommodations other than flying an expert out and having somebody do it in person. That may be an option that we exercise. I may talk to Mr. Brennan about that because I still want to have some transparency on that process. But what I don't want is to throw good money after bad at this issue when she's already spent $12,000, $12,200 and something dollars for absolutely nothing. This is not a matter of courtesy. This is a matter of obligation. This was a matter of Brady. It's no different. And by the way, the case that Mr. Brennan cites, he indicated that I cited that case. I didn't cite that case. Justice Gaziano cited that case in his opinion in the committee case. And the ultimate opinion of that court was when there is a discovery violation, when there is a Brady violation, and there is no question that that's what's before this court. Blatant discovery and Brady violations. The Commonwealth doesn't, the court may remember, by the way, on the witness stand when these videos were coming in piecemeal, especially the inverted video, 2 or 3 witnesses all went like this. I wasn't the one told it. I wasn't the one that downloaded it. You can. I wasn't the one that downloaded. I don't know where it came from. It just ended up on my desk on a flash drive. I don't know where it came from. Everybody was pointing fingers at everybody else. Nobody could establish a single chain of custody for those videos, and we still don't have it. So Chief Rafferty's statement, yeah, come on out, no hesitation whatsoever. They can come look at it. I suspect it's because she knew it wasn't there. This was we were led in a circular runaround. And it was ultimately at her cost. And that's what's.
So didn't the two of you, when you talk about good lawyering, didn't both of you agree that it was highly unlikely it would still be there? Or are you saying that part's not true? Mr. Brennan told me that.
I said, I'm concerned if we don't get out there fast. I don't know what the override protocol might be. So yes, I was concerned, but who cares? Well, that's no legal moment. What I thought and what Mr. Brennan and I discussed 3 years after the fact, when the Commonwealth has a self-executing obligation to provide that information to us because it's Brady. They also had an obligation pursuant to Mr. Yannetti's demand, not request, but demand to maintain that information.
So where is that demand? Is that in the file? Where is that demand?
February 2nd. I don't know what the docket number is. It was filed on February 2nd after arraignment.
Here?
Wherever the arraignment was, Mr. Yannetti.
It was in the Stoughton District Court.
Okay.
But it's part of the case file. And it stays with the Commonwealth, and that obligation stays with the Commonwealth. But I would propose to the court that even if the court's concern is, well, when was that filed and did Mr. Brennan
No,
actually?
I haven't seen it. I know it's not part of our file, and you're talking about it as if it were here.
Your Honor, I can't say with certainty, but I believe that it may have been submitted as an exhibit to a previous motion, probably early on in this case.
Okay, I just wanted our record to be clear.
Of
You're
course.
talking about Mr. Yannetti filed this. You did not file it in this court
I may have filed it as
as an
exhibit.
attachment, but it was
but
never
not-
any.
Right. There was, I don't mean to cut off the
No,
court,
no,
Judge.
it was never brought before me or a judge who had this case before me to be heard.
So there was early on, and so many motions have been filed in this
Right.
case, but early on, I did bring a motion, I believe before Your Honor, asking that all of the Stoughton District Court motions that I had filed at arraignment and thereafter be ratified by this court.
Okay.
That is in our record.
So I need you to find that
Happy to do it.
and tell us when it was filed, the act. I need to see
By
that.
the end of the day today, you will have whatever submissions we provided, and if it's not part of an exhibit, you will have that motion.
All right. Go ahead,
Just
Mr. Jackson.
to answer that one question that I can't answer because I've seen the filing. It was filed February 2nd, 2022, court stamped. My point is, even if that weren't the case, and it is the case, the obligation is self-executing. That's what Justice Gaziano was talking about when he talks about in the committee case, the self-executing duty that a prosecution has or a prosecutor has to maintain and preserve exculpatory information and provide that information to the defense. They didn't do that. And they led us to believe every single sign and signal, irrespective of what Mr. Brennan did or didn't actually personally know. The Commonwealth's conduct in this case, from the beginning of the investigation to now, suggested that that information existed. It DVR existed, sorry, the video footage on the DVR existed, and we were going out there to download. We shouldn't have had to jump through this hoop and go on this wild goose chase at Ms. Reed's expense. It is not, I think we can all in this courtroom agree, none of this is our fault. We didn't do any of this. It's all on the Commonwealth's shoulders. It's all their responsibility. They should have to pay for what happened when we went out there for absolutely no good reason. And I'll submit.
All right, Mr. Brennan, I have just a couple of questions.
Yeah.
So you don't know for certain whether this information was in fact downloaded onto the hard drive, but you suspect it is based on your conversation with the named gentleman in your affidavit?
So there's two different systems. One's called the DVR NVR. That's the actual system that keeps all the footage that's recorded. That has been
That
searched.
commonly is overridden every
Yes.
30 days,
Like has been overwritten.
statewide police departments.
Yes, Your Honor. And
Okay.
that has been overwritten,
Okay,
and there is no information on that.
okay.
When I spoke to the retired sergeant detective who had downloaded video, he said as a habit, he would routinely, when he would make a video copy from the DVR, he would place it in a separate file. I can't say that it's exhaustive. I can't say that it captures all of the video. It's when he would make a copy. And it seems in this case, there were select copies made. It doesn't seem that there was ever a time when somebody just copied the entire event. Now, the issue of whether there was a request for it, the obligation of the Commonwealth, I think is a separate issue. What exists on his hard drive in the detective file, I don't know. But what he has told me is he would routinely make copies of what he would provide to the court in the Commonwealth, or the Commonwealth and defense, and he would put on that separate file. I don't expect, and I'm only guessing, that it's going to be an exhaustive copy of the entire night of January 29th, 2022. I don't expect that. I expect it will be a copy of whatever it is that he has provided in this case. And so I think before it just lingers there forever, it should be copied and it should be provided to the defense.
All right, so I do want you and Mr. Jackson to talk about whether within the next week you do have somebody video it, or at your expense you send somebody out at it, but let's get moving with that. I know you said you'd make download a copy and send it. Are you satisfied with that, Mr. Jackson, or do you want to have someone there while that occurs?
I at least want to noodle on that for a second, but I'll talk to Mr. Brennan about it.
All right, I'd like it done within the week. The person has to be there within next week, or the Commonwealth will download it. We've got to get this case moving, and you want it, so it's got to be provided.
The stall isn't my fault. Yes, we want it. That's why we asked for it in the first
Yeah,
place.
so let's try and work it out before you leave here today, okay?
Sure.
Your Honor, I'm happy to defer the defendant's request. I'm prepared to do it now. If they want me to wait, if they want to have somebody there, I'm receptive, but we're ready to do it now.
All right, so I'm telling you to please wait, work it out, but no later than next week.
I understand.
All right, thank you. Did you want to be heard further? in
Briefly,
response?
Your Honor, although I've come into this case late, I am the Commonwealth, and I assume all responsibilities of the government's case in the history of it. This motion is not about a Rule 14 complaint or a violation. If the defense has a motion to sanctions or to dismiss, or whatever the remedy is, because they think they've been aggrieved, that would be a different motion. This motion is they're trying to get the court, or asking the court to impose costs because they had their expert come out at their request, and they were very clear about the risk associated with that. This motion should be denied. If there's a separate motion, we'll deal with that when it's filed. If I had known that the defense was going to argue something entirely different, and that is the failure to preserve, I would have made a copy of all Mr. Yannetti's motions and requests, and I would have provided them as an exhibit. But I did not do that because that was not the scope of this motion. This motion should be denied.
All right, thank you very much. Taking this under advisement. And do not wait for a decision from me on this about whether or not you send somebody out to
We
get
won't.
that video.
We'll get started on that immediately.
All right.
You like apples?
All right, so let's move on to the Commonwealth's motion for clarification regarding the search warrant, or the contents of the defendant's phone, more accurately. Please.
In reviewing the discovery in this case, I learned that there was a search warrant for Miss Reed's phone. That search warrant entitled the Commonwealth to search for data that's outlined in what's known as addendum or attached as addendum A. Learning the history of this case, I further learned that because there was an assertion of privileged communications, there was an agreement that the Attorney General's office would look through the data on the communications, and they would identify any attorney-client privilege information, extract it, and then provide the information back to the government and the defense. I am not sure of the accuracy, but I learned or read that the defense was given an entire data copy, forensic download of Ms. Reed's phone years ago. When I looked through the discovery, it surprised me that the Commonwealth did not receive the forensic data. It received a report. And when we reviewed the reports, it had references to navigation information and Google searches, but did not have any of the forensic download. And so clearly, the Commonwealth has a warrant, is entitled not only to the PDF extraction, they're entitled to the full force of that proof, which is the data. I spoke to my experts, and they advised that they believed that the data would have more information than simply a PDF. And so when I learned this, I wanted to both scrupulously protect the defendant's rights, but I also wanted the data for our review. And so I limited my request for the data to navigation information in the Google searches. Although I do not believe it was required pursuant to the communication protocol, I asked the Attorney General's office to engage in that protocol anyways, just out of abundance of caution and respect to the defense. I contacted the defense. The defense offered their objection. I think it has no legal merit whatsoever. They don't have standing at this point, but I noted their objection. I believe, without certainty, that the Attorney General's office has gone through that review to make sure there are no communications. However, they expressed some reluctance to provide the information because of the existence of the communication protocol, and they did not believe there was enough clarity that there was a distinction between navigation information. I do not see that navigation information, Google information, or the other data that I want is covered by the protocol. I believe that protocol has at least partially already been followed anyways. Time is of the essence. This case is on for April 1st. There is what I believe to be relevant material, important information, including Google information and navigation information that we are entitled to. I don't want delay. So I filed this notice so that the court could give direction, either assuring the Attorney General's office that they could provide the information, or if there is going to be a protocol, which I discourage, that it's expedited. If there is something the defense wants to look at prior to me receiving it, it should be on a very, very narrow time frame. I don't think they have a right or entitlement to review anything I get. I think the Commonwealth is entitled pursuant to the search warrant. If they have a remedy, it's after we've already reviewed it, not before. And so I'm doing this to facilitate things because I'm mindful of the April 1st file, and we will pursue this information and use it if relevant.
Okay. Is there an opposition? I don't have anything in writing.
Your Honor, not really. The only thing that we expressed to Mr. Brennan was, and maybe I misunderstood his first, there was a communication that we had on the phone. I thought that he was seeking something far broader than the search warrant. It sounds like he's staying within the parameters.
It sounds squarely within the search
Right.
warrant.
So that doesn't bother me. I want to make sure that whatever information he gets is squarely, as the court just said, squarely within those parameters. On January 28th at 9:30 p.m. until January 29th at 5:30 p.m. And otherwise, I don't disagree that pursuant to the search warrant, he can get the, I'm calling it raw data, but I think we all know what we're talking about. Not the PDF, but the underlying data.
All right. It's squarely within the search warrant.
Right.
I do feel Mr. Brennan did not have to come to me or even you with it, but I do appreciate that you did so. So yes. So the AG's office knows that you are entitled to that information. You may have it immediately.
Thank you.
Okay. All right. So the motion regarding, just want to get Commonwealth's motion for reciprocal discovery pertaining to employees of ARCA. And then if you go one step further than that, are we going one step further than that with the second motion today? Or do council want to come to sidebar and tell me any information you have? How do you want to do this?
Whatever the court's most comfortable with. An open court or sidebar.
I'd prefer to find out what's going on over in federal court at sidebar first.
Yes, Your Honor.
Mandy's learning about that loop. Good job, Mandy. Good job.
That guy just says bullshit.
Yeah. Yeah. All right. So she took the initial motion under advisement. I'm curious. I'd be surprised, frankly, if the defense did not file a preservation motion regarding that Sallyport video, at least when they became aware of it, that it existed, which should have been pretty early on. Like the part that confuses me about this whole 30-day overwriting thing. I mean, what? What are they talking about? This video has been around for 3 years. So now all of a sudden shit's getting overwritten. I have a sneaking suspicion that this upcoming motion to dismiss is going to delve very, very deeply into this particular subject matter. And I think we probably got a bit of a little bit of a preview from Jackson with respect to who may have known what was up with respect to this video, whether it existed, in that he's talking about Rafferty saying, oh yeah, have him come on in. Sure, there ain't shit there. We don't care. Have him look all day. So I have a feeling that that's going to be part of what they're going to be arguing took place here. So we'll see. No, I'm not in a hospital. I am in my friend's, I guess they call it the formal dining room. And I'm sitting in one of the thrones here. And that's not coming from me. That heart monitor is, let's see.
Do you want your food from here?
No, I'll wait for it for a second.
It's out here.
Thank you. Yeah, no, that's definitely Karen. Somebody's on life support in Karen Reed's trial. Who it is yet to be determined. We'll find out in a couple of months. So she took that under advisement. I would not be surprised if she does not give the defense any cash. And she says, we're just going to try to work around and get you what they have. See, the problem, which I don't know if people realize just kind of as trial observers, is judges are the gatekeeper of what comes in and what stays out at trial in terms of evidence. However, judges are not privy to the evidence in and of itself, meaning if there hasn't been a filing with respect to a particular piece of evidence or a particular statement or a particular report, the judge isn't going to know. The judge only finds out what is in discovery in a case as it comes to them piecemeal, as it's litigated, as to whether or not it's going to be admissible or inadmissible. So most of the time, judges are in the dark in terms of the full scope of discovery. So for instance, Judge Bev is not getting the state's full discovery file and saying, here you go, Judge. So you can kind of look through it and figure out, what they have a right to get and what they don't. That's not how this thing works. So judges don't know. They don't know. So they have to rely on the arguments of counsel. They have to do the best that they can to try to work through issues with discovery. And these types of discovery issues are not at all uncommon. They happen all the time. It's one of those things where, and Jackson kind of hinted upon it when he's talking about, I have no idea. You can't, as a defense attorney, you can't ask for something that you don't know exists. That's always the problem with Brady, right? Like we can't know because we don't have access as defense attorneys to the discovery until they tender it to us. So we're getting whatever they deem to be their responsibility to turn over to us. And we sometimes have to read through the tea leaves, or we have a witness tell us something that kind of opens our eyes. Oh, well, there must be something else if this witness said this, or there has to be another report because this witness said that they spoke to the cops 3 times. We only got 1 report. So things like that can kind of clue us in. But a lot of times, that's why you'll see, I'd say a vast majority of times, Brady violations pop up after the fact. And it's frustrating, because this concept of, Scouts honor, that the state has this obligation to turn over Brady material. You have to realize, just commonsensically, forget the law for a second, but just common sense is going to dictate that they have that's a very difficult conflict for them to overcome. But who gives a shit? They have to, and I'm talking about turning over potentially exculpatory evidence. Yeah, of course you don't want to do it. You've invested a huge amount of money prosecuting whoever you're prosecuting, and to turn over evidence that may make that turn out to be a huge waste of money is a problem for the state in a lot of different ways, or the Commonwealth, as is the situation here. Too bad. Look into these cases a little more deeply before you charge people then. That's my response to that. You don't get to pick and choose Brady material. If it tends to show that the defendant is innocent, you got to turn it over. Period. And Brian's a goddamn turncoat. That's all I'll say about that. Like, you rarely see a lot of prosecutors go over to the defense side, and for whatever reason that may be, that they think that they can make more money as a defense attorney, which is a misnomer. There's just, like I say it all the time, and there's a lot of aspects of defense attorney. It's the grind. It's really a situation where you've got to hustle quite a bit. It's feast or famine a lot of times as a defense counsel, unless you're in a big city and you've got a ton of huge clients that have a ton of huge money, which is typically, from the criminal side of it, white collar crime. That's where you're going to get, your biggest retainers. But, as far as this concept of a defense attorney turning prosecutor, it's pretty rare. It's not to say it doesn't happen, because it does, but it's much more common for defense attorneys to be former prosecutors than the other way around. So, because it's hard. Like, fundamentally, me in particular and my wife would never be able to be prosecutors. It's I'm too over on the people side. It's one of those things that I would have a fundamental problem prosecuting people. It's just I'm big on the rights of the citizens, and that's like it really is a fundamental thing. Yeah, Josh and AJ are great, but yeah, that's par for the course. That's what I mean. It's much more common for prosecutors to come to the defense bar than the other way around. Yeah, no, I'm still active. I don't have time to practice anymore. If Allison needs me for a trial, then we'll, of course, jump in. But yeah, no, I'm still active and able to practice. I can walk into any court and try a case in Illinois. I'm always going to keep my license active, but in terms of trying cases, I'm a creator these days. I don't have time for practicing. Career switch, that's what it was. But I can always harken back to my education and experience. That's the nice part. Yeah, we got speaking of Alec Baldwin, DB, we got a pretty interesting call yesterday from a guy who was working on that case in relation to Richard Allen. So Allie had a pretty long conversation with this individual, and it was interesting. So keep an eye out. We think it might be worth people's time to watch it when we end up having this individual on. And we think that, I don't know if I think I'm going to try to get Ian on. How'd you know? DB? I guess you just put that two and two together. He's not a firearms expert per se. He is, but he isn't. But it's a very specialized aspect of it. So, but yeah, like Runkle is very learned in the ways of guns. So Runkle will be a nice add for that. So I think we're going to have Runkle join us for that particular live, which will be great. We've been trying to do something with Ian for a while. So I'm excited about that. Yeah, it's in that arena, DB. It's pretty. He sent a shit ton of information. I was traveling. He sent like 20 different emails. This guy. So yeah, make sure that you guys keep your eyes out for that. Yes. Also, episode 6 of Murder on Songbird Road did drop overnight, so that is out. Make sure y'all are checking that out. That thing is starting to pick up pace a bit, and we are going to start digging in pretty heavily, Lauren and I, on that. Yeah, Runkle's great. So we're excited to have him on in the very near future, probably next week. What we're looking at. So, because I kind of feel, I'm not gonna lie, I kind of feel like I dropped the ball on the Rocky ASAP Rocky, because I wanted to. After I started reading about it, I'm like, man, I haven't talked to Lauren yet about if we're gonna do our Q&A tonight. I'll see what her deal is. Yeah, my biggest issue is the more intoxicated my friends get, the louder they are. So, I don't know if I can find a quiet spot where they're not screaming, but I'll see what I can do. And just so you all know, I do what I call a permanent record. So I record a large amount of the shenanigans that go on over this 5 days, which I'm going to at some point put together for all of us to listen to down the road, 20 years. Should be pretty funny. Some of the shit's highly inappropriate, though. It's not for public consumption at all. No, I don't have friends. I have to pay them. So, but they pretend like they're my friends, so that's good. At least I have that. Yeah, so I don't know if she obviously this ARCA issue with TUI and the limitations and what the feds are willing to turn over, which could be inconsistent with Rule 14 as far as the Commonwealth is concerned. That's what they're debating at sidebar right now. What I'm not clear on is to what extent. I'm sure the Commonwealth would love for neither of those gentlemen to be able to testify at all. But I don't know if they're asking for that as kind of a coverall, or if they are really just trying to limit certain things that they can and cannot say based on certain information they could not turn over. Let's see what they have to say. See what they figured out over in the corner.
All right, so I will hear you, Mr. Brennan, on your motion for reciprocal discovery.
Your Honor, we're expecting to file a certificate of compliance this morning. We've provided voluminous discovery to the defense, and it is now incumbent upon the defense to reciprocate pursuant to the rules. I filed a motion to reciprocate. Also, there is a specific motion regarding expert witnesses relative to so-called
Yeah.
market experts.
Thanks for hanging.
Those requests are consistent with information that we routinely provide pursuant to Rule 14. And we are asking that the defense comply if they expect to call these witnesses at trial.
And you've asked for, you have specific requests for the discovery, right?
I do.
All right. Mr. Jackson?
Thank you, Your Honor. I appreciate the opportunity to be heard on that. I appreciate Mr. Brennan's indication that he intends to file the certificate of compliance today. We know what our obligations are under Rule 14, and we intend to comply.
Okay. All right, so the motion is allowed. And Mr. Jackson, you had a scheduling concern?
I do. Concerning we received notice of discovery number 58 last night. It probably, I'm guessing it contains between a dozen, maybe 15 categories of new information that we're getting within that notice of discovery. They're substantial, including multiple experts, some individuals that we've never seen anything from. There, I believe that upon review and analysis, some or all of that will be relevant to our motion to dismiss, which I think is going to be pretty full-throated. The court indicated that it wanted us to file our motion to dismiss, I think, by the 11th, which is in 6 days from now. I don't think that's a reasonable possibility. We simply cannot get it done that quickly. I would ask the court, urge the court to allow us until sometime the beginning of March. We've got several dates on calendar. I don't have them committed to memory, but we'll be back at the beginning of March. That motion to dismiss, I think, if we have the time to do it and get it filed by the beginning of March, it's not going to take an enormous amount of court time. The time that's going to be taken is our preparation of the motion. But actually arguing it and ultimately the court either taking it under advisement or deciding on it, I don't think is going to be that burdensome. Although it's going to be a very, very full-throated motion.
All right, so you first raised the issue, I believe, in a footnote on one of your other motions that was filed, I don't know, January 21st or earlier, that this motion to dismiss is coming. You had a motion to dismiss it, the last trial, the same thing, forecast, and then it's coming, it's coming. I need that motion in order to get it heard before then. Let me hear what the Commonwealth has to say. What's the extent of the information that you provided today or yesterday?
In the most recent discovery,
Yes.
it was voluminous.
Okay.
We provided a number of expert witnesses, entire files of expert witnesses. We've been providing discovery in an ongoing manner rather than wait until the end. When I've retained an expert, we've notified the defense. When we have reports, we've notified the defense and provided them almost immediately. But there is quite a bit of information that we put together regarding expert reports and data information, accident reconstruction, phone investigations. So we sent it by link because it was extraordinarily large.
Okay. Does the defense anticipate evidentiary motions in this case? Got time that maybe I can flip these. Do you anticipate evidentiary motions?
I miss Yannetti. When's Yannetti going to start arguing?
I don't anticipate evidentiary motions from our end. Obviously, if that changes, I'll let the court and counsel know immediately, but I don't think so.
How about the Commonwealth?
There are none expected.
Mr. Jackson, I'll give you until February 20th to file that motion to dismiss.
Oh, shit. She gave a hefty extension on time. Last week, she wanted him to have it done by, I think, Monday.
We'll hear it. If there are no evidentiary Commonwealth, I'd like you to comply with your response if you could by the 27th, 28th. Oh, wait, this is March. I'm sorry. No, February 20th. Yes, if you could have it by the 27th, please. And then we will have a hearing on it on March 4th. If there are any evidentiary motions, they must be filed by February 11th. And I want you to talk about whether we have a voir dire of the defendant's proposed witnesses, because we'll have to do both at the same time.
Your Honor,
Right.
is it possible, I'm just looking at the calendar for the first time as the court's going through its calendar. Is it possible that I could urge the court to allow us 24th to file a motion to dismiss? That gives us a weekend. That is incredibly meaningful for us. I don't want to hamstring the Commonwealth if they need until the 3rd to give them a weekend.
No,
Possible?
but also I need weekends.
Right.
So it's not possible. So I'm giving you from February 11th to February 20th. I'll give you to the 21st.
Okay, 21st. Thank you, Your Honor.
Commonwealth, I'll give you to the 28th. Okay.
Thank you.
All right.
So Judge, are we taking off 218?
We're going to take 2/8. Let's keep it on now.
Okay.
If you work out if you believe that it would be helpful after talking to do a voir dire of those witnesses, we've got the 18th free.
The 18th of
February. You were supposed to be here anyway on your motion to dismiss.
Okay, I'll discuss it with Mr. Brennan.
All right. Thank you all.
Your Honor, may I?
Yes, I'm sorry.
A few things, housekeeping matters. One, I'd like to set a date for reciprocal discovery. There has been no
Yes.
date sent. I'd like to.
All right,
ask-
so you are filing your notice of compliance today. Do you have it now to file?
I do. Can I just show
Okay.
it to the defense?
Sure.
Oh, it's an extra copy? Okay. This one, if you want it. May I hand this in, Your Honor?
Thank you.
Thank you, sir.
All right. So all reciprocal discovery be provided by March 6th. All right, thank you all.
One last.
Yes, I'm sorry.
Come on, Brennan, jerk
No
off.
sidebar for this one.
Oh my God. And it's a sidebar. Why didn't you bring it up in the last sidebar? Brennan. So, all right. So this is where we're at. They got until the 21st to get that motion to dismiss on file. So you can anticipate that that should probably be a banger. Last one they filed was a banger. So, and Ajax keeps asking for time. So it really is going to be, as he said, full-throated. It's going to be a full-throated motion. I mean, they're going to be throwing some shit out there. It's to be guaranteed. And we know what that means when coming from these cats. It's going to be a lot of finger pointing, a lot of nefarious shit that they're suggesting is going on with this case. So should be a good one. Should be a good one, which of course we will cover. But up until that point, it sounds like it's going to be quiet. This was originally scheduled for today and tomorrow. There's obviously not going to be any court tomorrow, so don't waste your time looking for Reed coverage anywhere tomorrow because it's not happening. And we will get a ruling on whether or not she's going to pony up some cash or have the state, the Commonwealth, pony up some cash to reimburse Karen for her fees that she paid to the expert to travel out there to look at nothing. I don't know how she's going to rule on that. I tend to think she's not going to give him any money. I think she's going to figure that whatever they talked about doing after the fact with this hard drive, that's the only curative thing that she can do. She'll probably say something to the effect that, you know, they should have sent somebody from the defense team to make sure it was there before they paid somebody to come and look. Somewhat valid. But, you know, with all the shenanigans that have gone on with this case, but I fully anticipate that motion to dismiss is going to sound very loudly in discovery that has vanished, that the defense believes is exculpatory to Karen Reed. So I think that it's going to go hand in hand with some of the things that we heard today. I'd be surprised if it didn't. I'd also be surprised if we don't hear Chief Rafferty's name mentioned in there as well. I mean, he kind of showed his hand there a little bit, if you're paying attention. So, yeah, that's where we're at. As far as this evening, I'm going to reach out and talk to Lauren and see if we can do something today, maybe usually around that 5 o'clock hour Central Standard Time. I'm actually Eastern today, and I will be for the next few days. But if we're going to do that, keep your notifications on so you can find out if we're going to do a Order on Songbird Road Q&A.
Mr. Brennan, anything else?
Thank you very much, Your Honor.
Mr. Jackson, anything?
No, Your Honor, thank you.
All right. Thank you all.
Court, all right, please.
All right, so today it's mildly interesting. Let's get rid of that. Mildly interesting. It wasn't a fascinating day in court, but every part of it is fascinating if you dig in deep enough. So that's kind of where we're at with Reed. Like I said, let's keep the notifications on. I'll let you all know. I'll also put something in the community page whether or not we'll be going live with Lauren today. It really kind of depends on what's going on here as to whether or not I'll be available to do it. I definitely want to get it done. And I'll do it. If I don't do it today, maybe I'll see if I can roust her up early, and we'll do it tomorrow morning if there's nothing interesting going on. And I think what I'm going to do I think I'm going to work on a video for ASAP Rocky, because I think it's a case that I'm going to enjoy. And I think sounds like there's some pretty stout defense work going on over there. So you guys are amazing. I love all of you. Thank you for hanging this morning. Thank you to the mods for being the wonderful people that you are and hanging with me every day, and Allie last night. And you guys are the best, because without you, I am just an old man talking about lots of cases. Kale, New Garcia should be dropping today. It's out on Patreon, but it should be dropping today. So, all right, y'all.